A DWI arrest in Texas starts a secret second legal battle. It begins the moment you're stopped. You have precisely 15 days to request a hearing. Miss it, and your license is automatically suspended. There are no do-overs. This isn't about your criminal DWI case. This is a separate civil fight called an administrative license revocation, or ALR, hearing. And here, the state doesn't need proof beyond a reasonable doubt. Their standard of proof is much, much lower. We will now break down the entire ALR process, the procedure, the traps, and the tactics to protect your driving privileges. Right after the arrest, the officer takes your plastic license and hands you a piece of paper. This is a temporary driving permit. Why can they do this? It's a Texas law called implied consent. Driving here means you've already agreed to a test if lawfully arrested. The state's entire case against your license begins with the officer's sworn report, the DIC 23 or 24. It details everything. You face this license suspension for one of two reasons. You either refused to give a specimen or you gave one and it was over the limit. The punishments are different. A first-time refusal means a 180-day suspension. A first-time failure is a shorter 90-day suspension. But for either path, that 15-day deadline to request a hearing is absolute. Miss it, and the suspension starts automatically on day 41. This ALR hearing is administrative, not criminal. The dispute is with the DPS, decided by a special judge over one thing: your license. This matters because the state only needs to show their case is more likely than not true. A 51% standard is far easier to prove. The judge doesn't care if you're guilty of DWI. They can only answer 4 specific questions. First, was there reasonable suspicion for the stop? And second, was there probable cause to arrest you? Then, were you properly warned of the consequences? And finally, did you refuse or fail the test? Because the two cases are separate, you can win your ALR hearing and keep your license, but still be convicted of DWI later. They are not connected. So if the bar is so low for the state, how do you win this? The answer is found by using their own process against them. Consider refusing a test. You think, no test, no evidence, right? But that refusal can be used in your criminal trial as evidence you knew you were guilty. And a refusal doesn't stop them. Police frequently get a fast search warrant from a judge, allowing them to take your blood by force anyway. For commercial drivers, this is a financial catastrophe. A DWI arrest can disqualify their CDL for a full year, regardless of the outcome. Let's be perfectly clear. A truck driver can lose their job for an entire year, even if they are later found not guilty of the DWI charge itself. When you request the hearing, you'll often have a choice between telephonic or in person. One of these gives you a major strategic advantage. A primary way to win is proving a procedural error. That question about being properly warned, if the officer misread the DIC 24 form, it can be a complete defense. The most powerful move you can make is to subpoena the arresting officer. This forces them to appear and testify under oath, on the record. This is how you win. You aren't just defending, you're attacking the state's case. And if that officer fails to show up, the case is often dismissed. Filing subpoenas and cross-examining police officers is difficult. This is why having a skilled DWI attorney statistically improves your chances of winning. So you now know how to fight for your license. But what if this hearing was actually the key to winning your main criminal case? This hearing is the earliest, cheapest, and most complete chance to gather intelligence for your criminal defense. It's a free preview of the state's case. Recall the subpoena for the officer. It's not just for a default win. It's your one chance to lock them into their story, under oath, months before trial. This is why you must fight the ALR hearing, even if you think you will lose. The information gained for the criminal case is priceless. You can appeal a loss, but these appeals almost never succeed. You have to put forward your strongest case at the hearing itself. It's your only real shot, but victory is attainable. Recent statistics show 34% of ALR cases are dismissed outright. In total, 42% of drivers avoid license suspension. But none of these winning strategies are possible if you miss that 15-day deadline. It is the first and most unforgiving step in this whole ordeal. The Texas ALR hearing is far more than a fight for your license. It's a strategic battle that profoundly impacts the outcome of your DWI case. If you're facing a DWI in Texas, time is running out. Don't wait. Contact a DWI attorney immediately to request your ALR hearing before the deadline.